Right, good morning everybody. We are obviously here for the Countryside Rights of Way panel, 15th of March 2024. Can we start please with apologies?
Yes, thank you, Chair. Apologies received from Councillor Jill Waring. Thank you.
Thank you very much, and it's nice to see such a good attendance this morning. It's appreciated. Okay, we'll move item number 2. Has anybody got a declaration of interest in any of the applications? No? Okay. And item number 3, we've got the minutes held on the 16th of February. Seconder? Okay, second. All those in favour of moving them? Okay, thank you. Have you got a pen? Thank you. Thank you. And moving on to the main body of the agenda, item number 4, which is the Wildlife and Countryside Act 1981. And this is an application to upgrade public footpath 82 Ipstones Parish and public bridleway 85 Ipstones Parish to a restricted byway. Who's taken that?
I am, Chair.
Wonderful. Could you proceed then, please?
Good morning, Chair and members. This is an application made under Section 53 of the Wildlife and Countryside Act 1981 for an upgrade to public footpath 82 Ipstones to that of a restricted byway. Public footpath 82 is also known as of Mellow Lane. The application was made in 2014 by Mr Brian Smith on behalf of the Staffordshire Moorlands Bridleway Group. His evidence included an Ordnance Survey name book, a copy of Yates's map of 1798, a copy of Smith's map of 1817 and a copy of the current definitive map. In order to complete the evidence required to evaluate the strength of this Section 53 claim, it was firstly necessary to consider a Section 36 Highways Act 1980 application that had been received from the same bridleway group along Mellow Lane some years earlier. Under Section 36, an application can be made to the County Council requiring a route to be maintainable at public expense. In order to be maintainable, the route would have to have been in existence at the time of the Highways Act in 1835. The evidence along Mellow Lane was sufficient to conclude that the route had been in existence in 1835 and that by its character it would have carried carriage rights. This, therefore, was additional evidence that supported the Section 53 claim upgrade along Mellow Lane. The Section 36 report, appendices and addendum can be found within Appendix D of this report. Having ascertained all of the available evidence along Mellow Lane by concluding the Section 36 application, in the course of drafting the Section 53 Wildlife and Countryside Act 1981 report for Mellow Lane, it became apparent that the claimed upgrade to a restricted byway would end at public bridleway 85. On further consideration of the route, it was apparent that much of the evidence for the Mellow Lane application was potential evidence for the upgrade to public bridleway 85. Whilst there was enough historical evidence with sufficient authority provided by both the applicant for the Section 53 claimed upgrade and the Section 36 application to conclude that Mellow Lane should be upgraded, there was initially insufficient significant evidence to conclude that public bridleway 85 should also be upgraded on the definitive map and statement. However, on the discovery of the Railway Book of Reference and plan for the Leek, Coldon Low and Hartington Light Railway, this, together with the parish survey card for public bridleway 85, Yates's map of 1775 and the Ordnance Survey plans were sufficient to tip the balance in favour of the higher rights for the bridleway. Returning now to the start of the Section 53 application to upgrade Mellow Lane, which was received by Mr Smith in 2014. An initial consultation of landowners, statutory consultees and user groups was undertaken at the time. Only 3 responses were received. Ipstone Parish Council had no evidence to add, but did not object to the upgrade to Mellow Lane. A representative of the Byways and Bridleways Trust responded that they had ridden motorcycles over the route in the 1970s and 1980s, and a representative of the Peak and Northern Footpath Society stated that they did not have any evidence but did not object to the upgrading of the footpath. There was no response from any of the landowners at the time. Once the full report was drafted in 2023, which included both Mellow Lane and Public Bridleway 85, and the outcome of the Section 36 report and its own consultation of parties, the Section 53 report was sent out to the landowners, the statutory consultees and user groups. Ipstone's Parish Council responded that at a Parish Council meeting in September 2023, it was agreed to support the upgrade. A representative of the Byways and Bridleways Trust considered that in light of the substantial historical evidence produced, the documentation did support a finding that both ways carry public vehicular rights. Landowner 1, who lives along Mellow Lane, again made representations through their solicitor opposing the upgrade and citing the same concerns regarding nuisance, unsuitability and concerns regarding safety that they had raised for the Section 36 report. They provided evidence of their client's ownership, but did not, however, provide any further evidence either for or against the claimed upgrade. Landowner 2 owns land along Mellow Lane and supported the upgrade. She stated that she used to ride a horse along Mellow Lane approximately 45 years ago when there were stables at Pelham Farm. She states that gates are now locked along Mellow Lane to prevent riders using the lane. Landowner 3 only provided evidence of its ownership of land over which Public Bridleway 85 passes. Landowner 4 are leaseholders of the land over which the Public Bridleway runs and described the private rights along Mellow Lane. Within the landowner evidence form, they also referred to the Highways Act 1980 and that any claim made by users under this statute would be defeated due to trespass on the railway being an offence. This, however, is of no bearing because the upgrade is based on historical evidence alone. Landowner 5 completed an evidence form and made it clear that he had challenged any use other than that of a public bridleway. He has locked a gate to prevent unauthorised use and has stated that he also regularly parks vehicles and machinery in the track, restricting access to vehicles whilst allowing access for horses, bicycles and walkers. He explained that in 2008, a council official had been called out to the site in relation to a neighbour dispute and that the official was satisfied with the situation regarding the machinery and the public access. Landowner 6 received the landowner form, although does not own land directly associated with either the public footpath or the public bridleway. She did, however, object to the application. With this application, there is just one legal test which must be satisfied before a modification order can be made for the two routes. The test being whether on the balance of probabilities the higher rights do subsist. It is your officer's opinion that the application for the upgrade between points A to B and that discovered by the County Council between points C to D both pass the balance of probabilities test under Section 53 3C2 of the Wildlife and Countryside Act 1981. Your officer's recommendation, therefore, is that the evidence for the upgrade of Public Footpath 82 and Public Bridleway 85 Ipstones is sufficient to pass the legal test. I am happy to take any questions.
Thank you for that. So just to clarify, we're being asked to upgrade it to
a restricted byway. Both the public footpath and the public bridleway are both to be restricted up to a restricted byway.
But not for vehicles?
Not for vehicles, no.
Right, okay. I just wanted to just clarify that point. Okay. Do you want to speak? Oh, right. Carry on. You first.
Thank you, Mr. Chairman. I only have one question, and sorry for my ignorance. I am quite new to this panel, so the evidence is showing that it was an ancient highway. I thought that then took precedence. So could you explain to me why it's not being turned back into a highway, so for car use as well? Just for my own information, then I may have another question.
That is quite a difficult question, I have to say, from the 1835 Act. There have been a number of Highways Acts since 1835, and during those acts, they have prevented vehicular use on some of these older tracks and bridleways. If it had been a more substantial, obvious road, such as a turnpike road, then it probably would have continued to have had carried motor vehicles. But because in the past it would have only carried bridleway rights or carriageway rights, they tend to, in 1835 it would have been only carriages. That is what they have sort of continued to carry, as it were. I hope that answers your question.
Absolutely does. It makes it a lot clearer for me, because that was the only little bit. I mean, absolutely going with your recommendation. Thank you.
Thank you, Mr. Chairman. I think the evidence is there to upgrade A to B and C to D, to the two relevant things, really. I love it when they say it's danger to the railway or it's trespass, whatever it is. There's all these are excluded under the legislation. It's as simple as that. And if they're going to go to a solicitor, as this person is, you'd have hoped that the solicitor would have told them, we've got ground to fight, but these aren't the grounds to go with it. I'm in favour of grading it, but the landowner must be told, well, the landowner will be told, I presume, that it is been upgraded, and that they mustn't obstruct it. They mustn't stop any either pedestrian or horses' rights to use there, and go along with that. But I'm in favour of, well, I'll propose, if need be, that we accept officer's recommendation.
Okay, thank you. Speak.
Chairman, I'm happy to second the officer's recommendation, but I'd just be interested to know, these things come up and are very often very little used footpaths, and I wondered what evidence we had of recent usage, and I wonder whether you could help with that.
I'm afraid, Councillor Smith, I don't have much knowledge of how much recent usage there has been. I understand that it is still a public footpath and can be used as a public footpath. That is point A to B, and that point C to D is still being used as a public bridleway. But I wouldn't know sort of how often it was used, or I don't have any evidence of that, I'm afraid, if that's your question.
Oh, there we go. Zach, did you want to say anything? No? Okay. We have got a proposer and a seconder. Are we in favour of the two? I will read out two recommendations just to be clear with before we vote on them. Point A is that the route marked A to B shown on the map attached as Appendix B to this report be added to the list of publicly maintained highways kept by Director for Economy, Infrastructure and Skills. And B, that in response to the application made under Section 36 of the Highways Act 1980, the SMBPG be informed that the route referred to in the paragraph above is a highway which should be shown on the list of publicly maintainable highways. We've had a proposer and a seconder in favour. What's the vote? Okay, unanimous. Thank you for that. And we'll move now, please. Thank you for your report. We'll move on to item number 5, which is, again, Wildlife Countryside Act 1981, an application for the upgrade of public footpath 41 Sheen to a restricted byway Sheen. I understand this is a cross-boundary issue, so Laura, I think you're taking it, aren't you? Thank you.
Thank you, Chair, members. So this report is in relation to delegated functions regarding a cross-county border Section 53 application relating to the upgrade of public footpath 41 Sheen to a restricted byway. The route connects at the county boundary with Derbyshire in the parish of Hartington, where the same applicant has lodged a Section 53 application to Derbyshire County Council for the upgrade of public footpath 27 Hartington to a restricted byway. The route will be a continuation of the route applied for in the Sheen parish that has been made to Stafford County Council. Both applications are grounded on the same historical evidence and form one continuous route. The purpose of the report today is to seek panel's authority to enter into an agreement with Derbyshire County Council under Section 101 of the Local Government Act 1972. Section 101 of the Act allows for the discharge of functions from one local authority to another, and so in this case, Derbyshire County Council would delegate their powers to Staffordshire County Council to determine both the Section 53 applications that have been submitted to the respective councils. So to summarise, an application has been made to Staffordshire County Council under the Wildlife and Countryside Act 1981 for the upgrade of public footpath 41 Sheen to a restricted byway. Another application has been submitted to Derbyshire County Council for the upgrade of public footpath number 27 Hartington Town Quarter to a restricted byway. The route connects at the county boundary at the River Dove. The two applied for routes essentially form one continuous route, and as such, an anomaly would occur if Staffordshire County Council were to determine the application lodged with them prior to Derbyshire County Council making a determination on their application. Derbyshire County Council have agreed in principle to delegate their powers to Staffordshire in determining the section of the above-mentioned route and will request formal delegation from their committee. Staffordshire County Council have received direction from the Secretary of State to determine their application. Derbyshire County Council have not been directed to determine the application on their side of the county border. To conclude, officers seek approval from the panel to enter into an agreement with Derbyshire County Council to obtain delegated authority to determine the above-mentioned Section 53 applications as the applied for routes form a continuous route across the county border, and Staffordshire have been directed by the Secretary of State to determine their application. Thank you. I'm happy to take any questions.
Thank you. So this is not one that we need to make a decision on apart from agreeing to the approval.
That's correct, yes.
Okay. So anyone? Okay, I've got proposed. Paul, Carolyn seconded, and all those in favour? Okay, thank you. That was nice and simple. And we'll move on to exclusion of the public. I understand there isn't any items on that. So that's quite a swift meeting this morning. Thank you all for making the effort to come in. It really is appreciated, whether it's a small meeting or a long meeting. And please have a good day. Thank you. I always call him Zach. He knows who I mean. Yeah. It's just a bit of a